Hello, good afternoon, everyone, and from wherever you are. It is 2 p.m. in Uganda, so I don't know what time it is there for the rest of the people that are not in Uganda, but you're all welcome for this webinar. And as we wait for the rest to join, I want to call upon Joseph, who is our moderator for the day, to take us through the program and kickstart the session.
Thank you so much, Brenda. Good afternoon, ladies and gentlemen. I hope you're having a great time amidst the pandemic and all the challenges that have resulted from the change in our lifestyle. I welcome us all to this great discussion, the webinar on African level civil society policy engagement, focused on Africa's ascension to the Energy Charter Treaty. And the discussions will be around what it means for Africa as a continent and what are the alternatives. We are calling on several governments not to take it up. What are the alternatives? Our discussion will revolve around those two aspects. The purpose of the webinar is to bring together stakeholders from the African level to examine and share their perspectives regarding the implications of joining the Energy Charter Treaty. The other is to discuss the available alternatives that government can explore other than joining the Energy Charter Treaty. And then, most importantly, to record voices of stakeholders calling upon African governments not to accede to the Energy Charter Treaty. And also to deepen our knowledge, especially stakeholders like civil society organizations, media, and policymakers around the dangers of acceding to the Energy Charter Treaty in light of the increasing criticism about this treaty. Briefly, those are some of the objectives as to why we're having this discussion. And shortly, as more participants keep joining us, I'll be sharing the agenda with us, and we have a program starting. Thank you. I have been able to share my screen. We will have opening remarks from Ms. Jane Nalunga, the Executive Director at SEATINI Uganda, who will welcome us into this discussion. And then we'll have Lucia taking us through the second item, which is understanding the Energy Charter and the dangers that are likely to be faced by African states when they accede to the treaty. And under that discussion, we'll understand what the Energy Charter Treaty is and why Uganda and other African countries should really pay attention to this Energy Charter. The third item rather, would be understanding the existing policy alternatives that African governments can explore rather than acceding to the Energy Charter Treaty. And Brenda most likely will be taking us through this item. And then we'll have a plenary where participants will share their reactions from the presentations and have the way forward and closure done by the Honorable Flavia Ravhoro Kabahenda, the Chegu. Thank you so much. It would be at this juncture that I invite the Executive Director at SEATINI Uganda, Madame Nalunga, to welcome the participants and we kickstart on the discussion.
Okay, thank you so much, Joseph, and good afternoon to all the participants. On behalf of SEATINI and TNI, I would like to welcome you all to this research chat about the Energy Charter Treaty. What it is, where it is, why should we care about it, and what we need to do about it. I'm very happy that among our Amides, other than us, civil society, we have some members of parliament. As you know, maybe this is to our members of parliament, Uganda has signed so many agreements quietly, trade-related agreements, investment agreements, binding, and which have far-reaching implications on our economy, on our livelihood. As you are aware, members of parliament, there is, for example, the issue of the electricity, and government is, they are asking themselves, who signed such an agreement? How do we get out of it? So it's really, really important that we get to know about these agreements. I was talking to some people and they were asking, but what's this Energy Charter Treaty? Does it really concern us? Should we talk about it? This is what we are going to find out. Let us know what it is and let us know how to work around it. And this will help us to ensure that our government, their hands are not tied when they sign on to such treaties without really knowing what they are signing on. So Parliament, and also to congratulate you, Christine. I see Honorable Christine here, and for also having been picked to be on such a committee of environment and climate change, and also being a shadow minister. That means that what we are going to discuss will go straight into Parliament. Lastly, I would like to appreciate the partnership with TNI when it comes to this issue. TNI has really helped us to build our capacity around this treaty, and we have shared a number of papers explaining what the implications are of this treaty on our economy, on our environment, on our capacity to sustainably move on to clean energy. So thank you so much, all of you, for coming. Let us have an open discussion. If there is an issue which you haven't understood, let us debate and let us clearly chart out our way forward, not just as Uganda, but as East Africa and also globally, because this is also a global issue. Let us see how we can be able to work together to be able to fight against this very, very unfair treaty. So over to you, Joseph. I wish all of us a very fruitful deliberation.
Thank you so much, Madam Jane Nalunga, for welcoming all the participants to this fruitful deliberation. Without taking so much time, I'll invite Lucia, who will be taking us through the second agenda item.
Yeah, thank you, Joseph and Jane, also for the invitation and the mention also to the work that we're doing together with TNI. I have a PowerPoint, but I don't know if it's a good idea to share or if the connection will get bad, because otherwise I can do it without PowerPoint.
You could try with sharing the PowerPoint in the event that some of the participants are unable to hear or follow, then we can explore the other option. Okay,
so let me see how I do that. There. Yeah, so I think what's probably more interesting after this presentation, after the other presentations, is that we have a discussion. So for those of you who have already heard about the Energy Charter Treaty or other international investment agreements, maybe some of the things that I will say you already know, but I wanted to make a very also like, you know, introduction of what the treaty is, so we are all in the same page. But if you want to stop me at any point, just feel free to jump in and let me know. So, up there. So first of all, this is a picture for you to see, you know, when the European Energy Charter Treaty was signed, which was in 1991. This is in The Hague in the Netherlands, which is one of the countries that pushed very much for the treaty to happen. And the treaty was signed in 1991, which was, you know, immediately after the fall of the Soviet Union. And it had a very specific focus to secure somehow European energy capital outside of Europe, and especially in, you know, like post-Soviet countries. And in these meetings, you know, during the negotiations, during the drafting of the text and everything, a lot of European companies participated in drafting the text, like Shell, Exxon, Total, etc. And what they wanted is basically that the text was very open and very vague in the articles, so that it gave a lot of protection to foreign investors, well, to European investors outside of the European Union. So this is, you know, a bit of a context, so we also understand, you know, who was drafting the text and for who the treaty is most interesting to. Also, the ECT coincided with the proliferation of the signing of international investment agreements. This was in the mid-90s. As you can see in the graphic, in the mid-90s, it tripled the amount of how many investment agreements were being signed until 2019, where we have almost 2,600 international investment agreements signed. And most of these agreements include very similar provisions to the Energy Charter Treaty, with the difference that the Energy Charter Treaty is the first multilateral investment agreement. This means signed by not only two countries, like in bilateral investment agreements, but by different parties, and in particular focused on the energy sector. So this is one of the particularities of the investment agreement that we're going to be talking about today. So after all these negotiations, where we had Shell, Total, and all these big companies involved, as a result of this, we have today a treaty that includes basically far-reaching protections for investments in the energy sector. These protections, we can go a bit deeper if you want, but what matters is that the treaty as it is written, it is in a way that it gives the highest level of protection to investors. It gives, more, of course, like much higher protection that any national court or any national jurisdiction would give to foreign investors. And this is also why it is one of the preferred treaties for foreign or for big investors in the energy sector, because they know that with this agreement, they would be 100% protected, much more than any other national court. And one of the ways to protect this, to protect their investments, is not only by interpreting the articles that are written in the agreement, but also by using the private arbitration tribunals, which I don't know if you have heard of, but basically this is the investment, the ISDS, which is the acronyms of the mechanism that is being used by investors whenever they see that a state has, changed a regulation, passed a new law, has done anything that could go against their, their profits, their private profits, their benefits with their investments. But as we have seen until now, most of the cases that are going against states not necessarily have to do with, you know, like very radical things that the state have done, but most of the times it has to do with, you know, new regulations that the states pass, for example, to protect the environment, or to, you know, have a bit more of control over the energy and natural resources. So in a way, it's regulations that are, you know, in behalf of what the state can regulate. So it's not necessarily like really radical stuff that are going on. So the fact, if we combine these two issues, the fact that the treaty includes very vast protections for investors, plus a private tribunal where these investors can go to private courts to take the states into, you know, international arbitration cases, which are $1 million cases, it gives you a agreement. And as a difference to bilateral agreements, as I said, this is a multilateral agreement. So once you sign and you get in the agreement, it is not as easy to exit or to negotiate any of the clauses as it would be for a bilateral investment agreements, because we're talking about more than 53 countries who are right now part of this agreement, which we will see now, right now. So in this map, you can see who are the countries, which are the countries that are already part of the agreement, and that the investor rights apply fully. As you can see, it is all EU member countries, and also some Asian, Central Asian countries, plus Japan, and their most recently countries that joined, which are Jordan and Yemen. Only one country in the European Union has left, which is Italy. This happened in 2016, giving big reasons around, you know, how much money was being spent only, you know, in arbitration cases, and also in sustaining the ECT secretariat, because every country has to pay an annual budget to be part of the Energy Charter Treaty. So they left. Other countries that signed the international the Energy Charter Treaty but never ratified are Russia and Australia. And what is more important for us in this discussion are the countries that are in line of the accession, which are the green ones. You can see some of them are in Latin America, others are in Asia, but most of them are in the African region. So this is, yeah, the ECT expansion to Africa, Asia, and Latin America. As I said, Africa is the main target of the ECT Secretariat. I guess you know more than I do, but you know, there is also a discussion around how, you know, Europe is very dependent, highly dependent on energy products coming outside of the European Union, and this being mostly in Africa or Latin American countries. So of course, there is a geopolitical interest for the EU to expand the treaty to countries where they can make sure they can secure their investments for, you know, 20 years or even more. So maybe just going quickly through the process of, you know, what it takes to join the ECT. We divided this in 5 steps. This report on the expansion, we actually did together with SEATINI, and I will leave the link at the end of the presentation in case you want to read a bit. 5 steps start with the signing of the International Energy Charter, which is a political declaration. This is not a binding document, but it is a political declaration of countries who are expressing their interest to join the, you know, to sign the treaty. Then they are asked to prepare accession reports, which means that they have to present reports on describing the energy sector in their countries, describing, you know, how much investment there is right now, what interest there would be for foreign countries to enter the to invest in this country, and also to make a legal analysis on difficulties that there could be. So this is kind of like already preparing to, how other countries could start investing in this, in the country that wants to join the ECT. And as you can see, many countries are in this step 2, so that they have already signed the International Energy Charter Treaty. These are, I will only read the African countries. You have Benin, Gambia, Nigeria, Senegal, Chad, Niger, I'm sorry, I don't know how to pronounce that, Niger in Spanish, who are already in this step. But other countries, already signed the declaration, like Kenya, Burkina Faso, Mali, Rwanda, Sierra Leone. So these are countries that have already expressed their interest. The step 3, the next step would be to wait for the invitation from the Energy Charter Treaty Secretariat to access the ECT. So they will revise the accession reports, and then they will invite them. And then once the countries accept the invitation, as you can see, Uganda right now is pending, is waiting for this invitation. But once they receive it, the next steps will probably go fast, which means they would just accept the invitation and start the national ratification. Some countries are already in that step: Burundi, Eswatini, and Mauritania. And here is where, of course, you can make much more, pressure over the national parliaments, like to at least ask for public debates, because none of the European countries that joined the ECT in 1991 had any public debate or even asked for any, report joining the ECT to be done. So this is really important, because otherwise, once the country signs, all the investor protection that will immediately take place and be applicable for the countries. And leaving the Energy Charter Treaty is extremely difficult. So it is very important to be aware of the risks before you join it. So I'll just go quick through some of these risks. First of all, it has to do with, being exposed to expensive lawsuits for decades. And the Energy Charter Treaty has been actually classified as one of the most used investor-state lawsuits. At the moment, I'm sorry, this number has to be updated. There are 135 known claims only under this Energy Charter Treaty, which is by far the most used. And one of the reasons why it's the most used, it's also because it has the most vague provisions. So it is one of the favorite investment agreements by investors. Actually, some companies are just, opening like a phantom company in the Netherlands, so they can sue another country using the Energy Charter Treaty. So it is really one of the favorite treaties to be used. And as you can see, in the last decade, there has been like a 437% increase of known cases. So, this is showing that investors are already being aware of how profitable and what a good business it could also be to initiate this kind of cases. And it is one of the problems about the writing of the text being so vague is that, first of all, any type of investment can be seen as an investment that can be protected under this Energy Charter Treaty. So sometimes it doesn't even have to be an actual investment of money, but just like a contract, maybe just like an expression of wanting to invest in a country is enough for the treaty to consider this an investment. And the same goes to the investor. So any type of investor can use the treaty. So this could be, as I said, an investor that doesn't even have a fully, recognized company, which, it could be like a phantom company in the Netherlands. It could be an investor from fossil fuel companies. Yes, most of them are fossil fuel investors. And, it can also be, it doesn't even have to be like a company that is during exploration of oil, but it can also be a company that is trading or, selling oil. So it really is a big mess, because basically anyone can use the treaty. The other risk is that once you're part of the ECT, you're actually joining a very old type of investment treaty. It includes, the oldest type of investment protection that not even modern investment law recognizes as something that countries should join. So modern investment law, at least in the EU, is recommending countries not to join treaties such as the ECT. But at the same time, the European Union is pushing other countries to join the ECT. So there goes a little bit of this hypocrisy that you sometimes find in the EU capital, right? The ECT basically is as old as, imagine, it's as old as the first Kyoto Protocol. It's a very old treaty, but imagine how many rounds have been going every year to revise and to modernize the climate treaties to be adapted to, modern context. All that has not happened to the ECT. The ECT has not changed 1 comma since its creation in 1991. So it is actually not longer acceptable by academics, by lawyers, by even some judges who find it one of the oldest treaties and actually recommend countries to step out of it. Also, for some countries like Tanzania, Nigeria, who are actually walking, in a way to terminate old bilateral investment treaties or to renegotiate to restrict the rights of investors, this could be a huge step back for those countries, because on the one hand, they're trying to move forward and have modernized investment and trade law. And on the other side, they're signing into an investment agreement, which is very, the next risk would have to do with the climate crisis. As I said, this is one of the treaties that is most favorite for big oil, gas, and coal companies. These have been one of the main users of this treaty. And we have right now a lot of cases of big oil and gas and coal companies who are suing at the moment European countries, because these are the members who are fully ratified on the agreement, because of, for example, a new law that a government has passed where there are restrictions on the production of electricity used, through carbon production. There has also been a huge lawsuit against Italy because the government banned a mining company to operate in the middle of the ocean. So there, as countries are moving forward to be more climate restrictive and to have more climate friendly policies, and also to pay attention to the energy transition and how the energy transition should be undergoing, all these advances could be under risk, or at least they could be subtle to have a huge $1 million lawsuit if they are under the Energy Charter Treaty. And as you can see, almost 100% of investors who sued using the ECT were fossil fuel companies. Anyway, other risks. Reversing failed energy privatizations. So anything that that a state has moved forward in terms of energy transition could be obstacled if they are under this Energy Charter Treaty. I'm just going to go a bit quick because I don't want to run out of time. The same, if a country wants to put some action to reduce energy poverty, for example, by putting a cap on energy prices, this has actually already triggered lawsuits under the ECT. So these type of actions, which are actually actions that people expect governments to take, could be under risk if they are part of this investment agreement. And this is probably one of the most fundamental questions, which is how far can an investment agreement such as the Energy Charter Treaty restrict the sovereignty of the states over energy resources in this case, but in general, the right to regulate of governments, their legitimate right to regulate, right? So all of these are cases that have actually happened if governments do. So if a government decides to apply taxes on a windfall profits, if they force companies to hire local workers, transfer technology, or process raw materials before they are exported, all of these measures, which a government is totally legitimate to take, could be put under the eye of the Energy Charter Treaty. And governments, once they realize that they can get sued by $1 million, which is so much money they don't want to lose, they can actually rethink twice and maybe not pass such a law, just in case they lose the case, which is, by the way, most of this. So just to finalize saying where we are on the process of the expansion. So in December, the whole year of 2029, there was a bit of a pause on issuing invitations to accede. This revitalized a bit during 2020, where the Secretariat focused specifically last year to support ratification of countries that have already been inviting to accede, like Mauritania, Eswatini, and Burundi, to support the accession of countries already engaged in the ECT accession process, like Chad, Gambia, Kenya, Nigeria, Senegal, and Uganda. And well, the budget that they have spent for 2020. And these are some of the activities that the Secretariat did during 2020. And what do we expect, well, for 2021? As you can read from the 2021 work plan of the Secretariat, which I can send the document later, they said that they are putting some limited efforts in relation to expansion, but still they have a budget of 445,000 euros, specifically targeted towards the expansion process, and more specifically to support the completion of accession reports for Kenya, Tanzania, Benin, Panama, Cambodia, and to engage with countries that have been invited to accede, such as Burundi and Uganda. So they're in regarding resistance in other countries, there have been several actions taking place to raise awareness towards, the governments, for example, in Uganda and Nigeria, asking to join the ECT, not only in the East African region, but also Morocco, Chile, and Philippines have been undergoing some actions. For example, the Nigerian government was asked recently not to enter the Energy Charter Treaty. This was an action that was organized by PSI, Public Services International. So maybe just to finalize, some general reflections would be that although the Energy Charter Treaty right now is undergoing a modernization process, this has slowed down the expansion of the ECT because countries are, they are waiting to see how the modernization process turns out. But still, the accession process is not on hold. As we have seen, the Secretariat is doing meetings, is still, visiting some of the countries to explain to them why they should join the ECT. So we could expect that this and next year, this expansion process will move a bit faster. There is still a lot of secrecy and invisibility around the accession, and this makes it very have information and to make campaign. So it's really important for those of you who are in touch or in contact with government to ask for information, to know at what point of the accession these countries are. And, it's very important to make this more transparent. And of course, the importance to strengthen collaboration, both, with Southern partners and the European campaign, and to even think about the possibility of organizing an international campaign. And to reflect further how we can better collaborate, from both sides on making noise around the process of accession to the Energy Charter Treaty. So thank you very much. These are two of the most recent publications that we have done on the Energy Charter Treaty. The blue one is specifically on the expansion process, and the yellow one is broader around what the Energy Charter Treaty is. I will share them both in the chat, and I'm happy for any questions.
Thank you so much, Lucia, for taking us through what the ECT is and the package that it comes with, as you shared the issues, including expensive lawsuits against the states, the risk and challenges around climate change, especially with the investors focusing on the fossil fuels, the whole aspect of energy privatization, and then restricting sovereignty over energy resources. Colleagues in the chat kept sharing experiences. I see Mina posted something, and Jane posted something. Why a new treaty, the ECT, when they can use bilateral investment treaties that are already signed? If colleagues permit, I'll invite Brenda at this point to come and share with us the policy alternatives, and then we have the general plenary. Having heard what comes with the ECT, then what are the alternatives if we can't take it up? Brenda, are you ready to take the floor?
Yes, Joseph, thank you very much. And
You're most welcome.
Thank you, Lucia, for that very insightful presentation. I think it has even helped maybe some of us that do not clearly understand what the ECT is, what the ECT contains, or how this topic is even relevant on the African continent. Much as I would want, before I get into my presentation, I just want to maybe give a brief, just a second, I am trying to share my screen.
As you're sharing the screen, Lily is asking, what are the perceived benefits of joining the treaty that motivate countries to join amidst such far-reaching challenges?
Yeah, maybe just before they get ready with the next presentation, I just see like one question by Jane on why they would like to join the ECT if there are already other bilateral investment agreements in place. I would say that as I said, like the Energy Charter Treaty would expand the investment protections to all the countries that have signed it, which are at the moment 53 countries. So you would have to revise and see what bilateral investment agreements are currently in place, for example, in Uganda with which countries, and you would see that by far these are not covered, in all those 53 countries. So it would give access to many more companies coming from many more places. And also some of the bilateral investment agreements, they might have other type of investment provisions and investment protections. And the Energy Charter Treaty is very clear on this. And as I said, it has one of the worst type of investment protections. So it is a really much likable and fair investment agreement for investors. And it's also more, kind of comfortable for them because they only have to worry about one huge multilateral investment agreement. And as I said, it's much harder to step out or to withdraw from the ECT than from any other bilateral investment agreement. So that's also a big risk. Yeah. And if there are other questions, I'll just try to answer them through the chat.
Thank you so much, Lucia, for responding to Jen's concern. You could as well speak to Lina Asimwe's question as Brenda is setting up. Lina asked that what are the perceived benefits of joining this treaty that motivate countries to join amidst such far-reaching challenges?
Yeah, so this is a really good question because, well, I mean, if you read some of the documents that the Secretariat prepares to kind of like convince countries to join, have to do basically because they say that, having this agreement, it will attract more foreign investment, and especially in the energy sector. And right now they're using a discourse which is a bit, dangerous and challenging because they're using the ECT as a way for countries to transition on their energy. So like it's a way to invest on renewable energies, for example. But it doesn't say that investors have to only be renewable energies. And if you look at your countries and you see what the current investments are and who the foreign investors are right now, I'm sure that most of them are in fossil fuel investments. So these are the investments that the Energy Charter will protect, not any other investment. So what they say is what they say with any other investment agreement, which has to do with attracting foreign investment agreement and also giving, you know, like security, like how to say, like judicial security for investors. But, you know, I think all of these arguments have been demonstrated that are not true, and basically that there are much more risks right now. I like to say that this is a bit of a boomerang effect for European countries who actually signed the ECT thinking that it would be such a good agreement to secure their investments outside of Europe. And right now, all of these countries are being sued by their own, you know, countries, like Finland is suing Germany, Spain has been receiving so many lawsuits from so many other European countries. So this type of boomerang effect is something that maybe they thought that this was not going to happen to them, but it's actually happening. And it's happening because it can happen. So if there's a minimum, you know, option for this to happen, you can be sure that it will happen. So yeah. And also another fact that most of the ECT Secretariat is talking mainly with the energy ministers, and energy ministers do not necessarily have to be aware of trade and international investment law. So yeah, so, you know, sometimes they can miss out a bit of the dangers of what a trade and investment agreement is, because they only focus it as an energy agreement and cooperation.
Thank you so much, Lina. I see that Caroline has also placed her question in the chat. Are you able to view it?
Yeah, I see.
Yeah,
I think what Caroline is saying is very important to bear in mind. You know, the conflict and how incoherent it can be with actual laws that are in place right now. For example, I can say the example of Spain, that Spain right now is passing a new law on climate change, and everything that the law says on climate change can be subject of new lawsuits from fossil fuel companies and other energy companies under the ECT. So let's hear now, and I'm really interested to also know what other type of policies, you know, should be rather in place to actually attract foreign investment, or what type of investment or infrastructure should be in place in the countries for a good energy transition to happen. And this has really nothing to do with having an investment agreement in place. But yeah, I'm curious now to hear the rest of the webinar.
Thank you so much, Lina, for responding to the concerns being raised by some of the participants. I see the chat is heavily engaged. People are asking for the policy briefs on the ECT. Brenda, are you ready to pick it up? Brenda? Brenda, are you ready to pick it up, or we can engage?
Yes, I am. Yes, I am. Sorry, I forgot to unmute.
Oh, it's okay. You can just do the slideshow for purposes of better visibility for participants.
Okay, just a second.
Probably here at the bottom, you'll be able to see the icon for the slideshow.
I think you can. Okay, is that clear enough?
Yes, it is.
Okay, thank you very much. Lucy has really tried to discuss this broadly, but I'd prepared my presentation in a way of trying to give a brief recap on the energy charter structure, which I think is not important because Lucy has really tried to illustrate how it started and where we are right now. Maybe just to go straight to what is on the African continent. Yeah, the status of the ECT in Africa. And like Lucy was explaining, she clearly brought out some of the major features that the ECT contains and why any country, especially those in the global south that have not ascended to this treaty should not, because it is a major threat and like it is highlighted as one of the most dangerous investment agreements. So countries, especially in Africa, that have not been part of the treaty, it is very, very fundamental if we put it to a halt and wherever we had reached and decide not to ascend or even join this treaty, because the dangers attributed to it are even much higher than the advantages that we would get through joining the ECT. Now, my topic is basically on trying to bring out some of the policy alternatives, but I want to approach it from two different angles. One, it is important for us to look at the alternative investment opportunities that the government can explore. For instance, like Madame Jane was asking, if we do have the already existing BITs, then why do we need a separate treaty, which we are not even sure about as regarding the content? So we could perhaps look at the alternative investment opportunities that exist as a result of those bilateral investment treaties, those agreements that are in place, the United Nations guiding principles, and we could base on that. But also the second approach that I would give to maybe this topic is that there are different aspects that the government should give priority other than us rushing into ascending to a new treaty, which we are not even sure of, and we are not well detailed with what it contains. And like Lucy was sharing, one of the other problems that we have faced with the ECT is like when you look at Uganda, most of this work, especially regarding ratification and whenever there is a new agreement in place, an investment agreement, this is usually handled by the Ministry of Finance. Now, when you look at this ECT, it is under the Ministry of Energy. And we cannot run away from the fact that most people do not understand the contents, and we could be in a rush to sign this when even the policymakers or the people that are take charge of this do not understand the contents. And we are likely to suffer the major risks that are attributed to it, just like Lucy shared with us. So from the African perspective, gladly not, actually there's no country that has already been part of the treaty, but like maybe Lucy shared, so I think I don't have to go through this again, but you can see from my screen some of the countries that have reached at a stage of national ratification. Now, for us as Uganda, I think it would also be important to talk about our position. Right now, we expressed our interest, but we are still waiting on us to be invited to ascend to the ECT. And that is why this is a very important time for us to come up for the stakeholders that are here and the MPs and everyone that is responsible, and the climate activists. I've actually seen a lot joining. It is high time for us to come up and say that wherever we had reached, we should run away from this particular treaty, because we cannot even want to think about the dangers that are going to come attributed to it. Now, the major question would be, why would anyone even join the ECT? And why would countries like Uganda want to even be part of this ECT? So there's a lot that has been said, and trying to encourage any state to join the ECT or to be party, but especially the low developed countries or even the developing countries, most of them have a high urge of attracting foreign direct investment. So when you look at some of the contents for the ECT, it ensures that by ascending to this treaty, you are able to access and to attract and promote the FDIs as one of the reasons. So a country like Uganda that seeks to broaden and develop its energy resources will be in a rush to ascend to such an agreement that assures them of foreign direct investment that assures them of a platform to engage and influence globally, to have their decision and say, because there has been also a talk around modernization of the energy. So such reasons are so catching that any country would think about joining and being part. But as you can see, most of those are actually just myths. Nothing is actually a reality, basing on the countries that we have seen that are part of this ECT and the very risks and consequences that they have faced. So we think that the talk around investment, helping the climate, is actually the direct opposite, because the reality with what comes with the ECT is that it is not a treaty that is going to directly lead us into investment. If it's about investment, we shall, as we go on, establish that there are several agreements that can foster development and investment, but not specifically the ECT. And the other thing, especially with regarding to climate and the status that we are on right now, it is a high risk for Uganda or any country on the African continent to actually think of being party and even thinking that this one is going to help in mitigating the climate change that we have at the moment. Because when you look at, for instance, I'll give you an example of Kenya, what happened recently. There's a campaign around saving Lamu. You realize that once you're party to this treaty, you do not have such flexibility. And like Lucy was also sharing, you find by trying to mitigate on behalf of the public, say the government, you are infringing on the investor's right. And you are likely to be subjected to an arbitration settlement, or you're likely to have that raise a dispute. So it is a very risky position for any country, especially these developing countries, to even think about being party to these treaties. But we cannot isolate the fact that there is need for development, there is need to boost and grow our economies. So one of the things we would look at is, if we are saying no to the ECT, then what should we actually take in place? So I had also highlighted some of the major risks, but Lucia has also shared most of them, and it is not important. Maybe just to say on the issue of investor state dispute settlements, I think for now, as Uganda, we are still at an advantaged position because we have seen the government being subjected to these dispute settlements, but most of them, like you know, Uganda has succeeded. But you cannot always be assured that that is how the position is going to be, because there is the ECT arises when you actually look at most of the arbitration settlements. Most of the cases that have arisen out of the investment agreements are attributed to the ECT. So we cannot risk an already crippling economy to a situation where we have to let in a lot of money being lost as compensation in case such matters arise. And also the issue of environmental protection. All these reasons, as you see, and as Lucia already elaborated, when you think about them, you find a lot of reasons as to why where we are is actually worse. But even thinking about bringing in a new treaty that is going to embed us into a situation that we cannot easily get out of. And maybe for those that had not joined, or if I don't know if Lucy elaborated on that, the ECT has what they refer to as the zombie clause. So the moment you're party to it, even if you exit, you can still be subjected to an arbitration or a dispute settlement, even after 26 years. So you wouldn't even want to imagine a state that you would be in upon ascending to such an act and you have no way out. We already have challenges, like for instance, in Uganda, we have Umeme, And it would be very difficult for the government to come up and maybe try to say, let us cut the utility fee that you have to pay for electricity, because it does not have power or control over it. So even that is exactly what the ECT does. It is majorly meant to protect the investors as compared to the government. So when we accept to subject ourselves to the ECT, then we know that the government it will not actually have any space to mitigate on behalf of us as the public, but rather all it does is try to protect the citizens. And just like an important question had been asked earlier, why do we need, or why is the ECT even so special? We have, and maybe just to say, this ECT is not a standalone agreement. It is just an international investment agreement, just like we have several other international investment agreements. So when you read the report from the United Nations Conference on Trade and Development, we have around 2,369 BITs that are existing at a regional and a multilateral governance level. So they also have a lot of loopholes that exist in those BITs. And we have over time been trying to look at how we can reform most of these BITs that are existing. So it would be important if a government decided, or if governments decided to concentrate on reforming the already existing BITs than ascending to a new BIT or new agreement where you are not assured at all of the protection that is there. And most of these challenges that were shared by myself and Lucia are not just with the ECT. This cut across all the BITs. We have a very huge challenge when it comes to the ISD, the investors state dispute settlements. We have a very big challenge when it comes to investors' rights being higher than the states' rights and even overlooking them. So when we are sharing the experiences or the challenges that are attributed to the ECT, we are not isolating those that are attributed to the BITs. But what we are trying to point out is that, can we instead concentrate on trying to rectify or to reform the already existing agreements? For instance, when you look at what we have at a national level in terms of the investment protection. In Uganda, we have the National Investment Code Act of 2019. We have the PPP Act, and there are also the investment regulations being developed. Like I had said earlier, any country would join the ECT, and one of the major reasons would be to attract FDIs. But if we are looking at it from a Ugandan perspective, when we want to attract FDIs, or if we are looking for one of the major ways, or any legal instrument that could guide us, we already have those at a national level. And in fact, when you look at when you try to weigh the two, you realize that the existing national investment agreements that we have are much better because the government has control over them and they can always be adjusted in the interest of the citizens, which is totally different with the BIT. So instead of us concentrating on bringing in a new law, it would be very fundamental if we looked at the possibility of reforming our existing investment legal frameworks. Like when you look at the National Investment Code of Uganda, it has policy gaps. For instance, it does not talk about the protection of business and human rights, which is very fundamental because in whatever we do, human rights always have to come at the forefront. But we have gaps and we have seen a lot of violations within the investment schemes, which tend to be as a result of this. So it would be important if we as a country concentrate on reforming and advancing our national legal frameworks other than looking at bringing in a new law, much as we saw that it is also trying to be modernized, but it would be important for us to focus on ours and also look at certain ways in which we can reform them. Because some of the major challenges that we have faced within the investment sector is that true, we have the investors and perhaps the mechanisms that we have in place have been able to attract some kind of investment. But the challenge is we still have a huge gap when it comes to regulate these because most of them are as a result of the bilateral investment treaties, and they tend not to respect or adhere to the domestic regulations, which puts us in a very difficult position, because at the end of the day, it is the citizens that end up suffering the consequences that are attributed to these investment schemes. So what we think is we have very much looked at the dangers that are attributed to the ECT, but then the government will tell us that we need investors to come in the country. We need to boost our economy. We need transformations within the energy sector. So what we have is we can present to the government that much as we understand the need for attracting and promoting investment, there is an alternative. We can concentrate on building our national laws that are already in place. And also these investment regulations that are being developed, we could actually look at how we incorporate any aspect, maybe from the energy perspective, that even whatever is not covered for under the Investment Code Act can be covered for under the regulation, so that we are not left out and we have a very strong law that can still attract investors. And definitely Uganda has done a lot. We have incentives, we have put in place mechanisms to try and bring in all these different sorts of investments. So for me, I think, and like we have shared, we do not need a standalone law, especially on energy. And also the major issue that we have, people do not understand it. Even I highly believe that most of the policymakers that were involved in expressing the interest were perhaps not well versed with the contents of the act, because when you try to check with the ECT, it actually contravenes the Paris Agreement, which makes it invalid as far as the international regulations are concerned, because any law as regarding to the United Nations Vienna Convention rather, such a law that violates the norms of international law, like those stated under the Paris Agreement, it becomes null and void. So I think by us rushing to sign, we have not made enough research. We have not read so much to understand what this act is or what it brings to, or the risks that come with it and the implications. So we probably do not need it, but we can build on what we have. And maybe to look at the other alternatives, or maybe I would say instruments that we have that could still guide us and foster that investment and development of the country that we would need, is we have the current conversations that are going on at about the AFCFTA. We also have the investment chapter there that is being developed. And I highly believe that this is one of the major instruments that could help boost the economic growth and investment within the sub-Saharan Africa. So we could instead concentrate on, since this one is still new, we could also look at how we could highly benefit from the ASCFTA and have all our demands or requests being put under there, instead of going for the ECT, which is to that have been shared. And the other thing is we have BITs. I could not mention each one of them because, like I said, there are over 2,000 BITs existing at a regional, and continental and global level. So we already have these laws, we already have these investors coming in place. We do not need a law that is going to expose us to all those risks. Now, the other issue has also been on the aspect of human and environmental rights. How assured are we that this act is going to come on board and it incorporates the human and environmental rights? Because like Aaron shared, one of the major challenges that we have seen with the international investment agreements is that most of them are incompatible with the human and environmental rights. And the moment you do not respect the rights of the citizens or the environmental rights, you are exposing the whole country or the whole continent to a very high risk and very difficult position that it may not be easy for us to get out of. So in a nutshell, we need to also be sure that the agreements that we are signing, which we exclude the ECT, because we have exhausted every content that the ECT has. We look at how about bringing on board agreements that incorporate the human and environmental obligations that respect the aspect of human and environmental rights and also business rights, so that we have laws that are friendly to the investors, but are also friendly to our citizens. And no country is under an obligation to enter into an agreement if it does not incorporate the business and human rights. But I think that is why we even have to go back and look at the ECT and look at how we can run away from it, but still not leave out the economic demands that we have. Maybe just to also add on, we need to look at how we can go away from dependence on fossil fuels, because that is very key when we talk about climate action. We are in a very difficult time where we cannot just look at bringing in a law that is going to keep us in one position, because the moment we have signed it, then we lose the respect, or we lose the right to come up and say that now we want to run away from fossil fuels, or we want to maybe promote clean energy, because we may probably be infringing on some investors, and it is going to be very problematic. So maybe just to wrap up this, some questions would be what can be done, or because right now, and I saw someone ask earlier on, what can be done when, for instance, a country is in a state or in a position where they've already expressed their interests. So we have different people, sorry about that. We have different people on board that are from different sectors. So what can be done is not just for the MPs, but we also have the climate activists. We have the youth on board. We have the legal representatives on board. So it is a combined effort. We can all join hands and call for the urgent review of Uganda's request to join the ECT, because gladly it is not too late. And maybe I would say gladly it was put to a halt, but this is the right time we have to come up and tell the government why we think this treaty should not be assented to. Maybe most times the mistake we make is we only come to share our expression, and we don't want certain laws, or we do not want certain principles, but we do not come up with alternatives. And that is why we have probably tried to break down and prove to everyone here that we indeed have alternatives. And the alternatives are far much better, and they would help to protect us, and they are a bit friendly. But it would be very, very problematic for us as a country to try to join the ECT. And since we have realized when it is still early, because remember, the moment you have joined, even if you try to exit, or even if you exit, the member states can still sue you even after you have exited because of that zombie clause that I've talked about that exists within the ECT. So we have no better time other than now to come up and join hands and tell the government as to why we do not need the ECT to be a treaty that is assented in Uganda. The other thing, we can also call for better legislative examination of, and actually talking about this, like I had earlier on said, this is not a call where we shall only talk about the ECT and the dangers. Then the next day we come back and talk about the dangers of a certain bilateral investment treaty that is in Uganda. Maybe it is about this time that we actually look at the the points that cut across when it comes to international investment agreements, where this falls. And we look at all those that I've shared. We come up to propose for better legislative or better policies in place. And we also ensure that the future investment agreements or the bilateral investment treaties that we sign are compatible with Uganda's commitments and also are compatible with the United Nations guiding principles on international human rights and environmental protection. If we do that, then we shall be able to stand firmly and say that we have investment agreements, because we believe that the government can listen to us when we go to them and present our cries and our reasons as to why this should not be put in place. We believe that perhaps something can be done, and it would be very effective if our voices can be heard, and if we can use our voices to even amplify the voices of those that cannot maybe access such a platform, then it would be very important. And that is all I had to share with you. Maybe I would conclude with saying that the ECT may be a bit, I am sure that some of you are here and it is the first time you're hearing about it, especially the climate activists that are on board. But this is a very fundamental issue, and it is about that time where we put hands together and call for the immediate action and make sure that we do not get into a position that would be difficult for us to get out of. So I will take on your questions, but for now, thank you very much for listening to me.
Thank you so much, Brenda, for ably sharing with us the alternatives. After Lucia's presentation, probably people are asking, okay, if we are rejecting the ECT, then what policy alternatives do we have as Uganda, as East Africa, as Africa? But you've ably mentioned some of them, and off cuff, I noted here in my notebook that the need to strengthen the legal framework when it comes to investment here in Uganda could be an alternative, something I passionately believe in. And then in the face of climate change, we need to think of other energy sources other than fossil fuels, and largely placing human rights at the center of making investment decisions. I welcome the Honorable Vyaika Lawrence Songa. He joined us during your discussion. He's the chair of the Parliamentary Committee on Climate Change and the MP for Ora County in Zombo District. I will open up the plenary for colleagues that have matters of concern, contributions, those that are seeking clarity on both Lucia and Brenda's presentations. We shall use the, yes, Honorable.
Yeah, thank you very much. First of all, I'm very sorry for joining you late at another meeting, but I'm very grateful that you are discussing this. My name is Bika Lawrence Songa, Member of Parliament for Ora County in Zombo, in West Nile, and also now I'm actually I was appointed 2 days ago again, reappointed as the chair of the Climate Change Committee. First of all, I want to say we need laws. Actually, we make laws to protect the planet, to protect the people, and to protect the profit. In 2018, at Columbia University, we discussed about investment treaties. And the position was that we should continuously review our investment treaties and agreement so that we can still work in line of protecting the planet, the people, and the profit, or what you can say, the economy. And therefore, I know Uganda has taken some steps in signing the ECT in 2015, and Uganda also signed the World Trade Organization Treaty in 1995. What I want to clearly say is, what is the urgency of the ECT? I'm very glad that this was signed in 2015 before I came to Parliament. But as far as following up on this law is concerned, it is going to be when it is going to find us here. And there is no way we are going to pass such a law which is going to protect some foreign investors. We have many ways to protect foreign investors in Uganda other than signing the ECT, because some of the investments may not be in line of protecting economy and people. And that's the thing, there is no urgency of signing or ratifying the ECT. There are many other ways we can attract foreign indirect investment to Uganda, giving them incentives and so on. So that is one position. When it comes to investment like in fossil fuel, like the Uganda, we have estimated 6.5 billion barrels of petroleum. And if we sell it at the current price, we would be raising something like $416 billion. But you know, our oil is actually, what is recoverable is only 1.4. So if we sell that one at the current price, we are going to get $89.5 billion. Now, the dilemma we have with international communities, the position is by 2030, we should leave this petroleum underground. We have to do a lot of cost-benefit analysis, because if we are leaving the petroleum underground, so what alternative, where are we going to get these monies I've mentioned to do the infrastructure, which if we don't do, there can be political uprising. So this is the dilemma we still need to negotiate. But of course, we have to move towards renewable energy, which are environmentally friendly, but it has to be a step-by-step thing, not an abrupt. We have to do a lot of cost-benefit analysis. I'm an environmentalist, but I'm not an environmentalist who will talk about environmental protection. Don't touch. We have to touch, benefit from it, and also leave more for the future generation. So we more of conservation, which is wise. So that is very, very important. So investment treaties must be reviewed and renegotiated. We know energy is very key. The energy is very key to the economy, but we have to use other channels than signing the ECT. And then along this line, I call upon all the stakeholders, civil society, private sector, government, and academia to involve the stakeholders, involve the policy, so that they understand what treaties we sign under the World Trade Organization, and this awareness is key. As far as it is concerned, we also talk about cross-border. Uganda has been working along the Green Grid Alliance, where we are talking about under the International Solar Agreement Alliance, Solar Alliance. we are free to have discussion to look at these energy resources. Another one, there will always be negotiation other than signing the ECT. So the Paris Agreement which we signed, we have to work along that line so that we can, and then the world trade issues, these issues of energy use, efficiency, and so on can also be discussed under the world trade issue of trade and climate change or the environment, which Uganda is a part. So for me, I think there is no emergency to bring the ECT now. And even if it comes, we shall say, no, it is not very urgent. We can use other laws to attract investment in the country. We have the Paris Agreement, we have the world trade issues, but also we need to review our investment treaties. Then lastly, I want to say that where is the pressure coming from to push Uganda to sign the ECT? The pressure could be coming from foreign investors who want to protect their businesses at the expense of the people and the economy of Uganda. So since we are in Parliament, this thing will come to us and we shall definitely work with you to see that we address it. Thank you very much.
Thank you so much, Bika Lawrence, the chair of the Climate Change Parliamentary Committee, for those views. I see that people are commenting on these issues in the chat. Let me try to read out some of them. I see Jane is one of the most active participants in the chat. She was expressing fear that they could bypass Parliament and then some ministers end up signing these treaties. I don't know if you have a response to that.
As far as the energy charter is concerned, this is a very key thing, and we have the relevant committees here. There is no way you can bypass Parliament and it straight to Cabinet. And also, the person who signed on behalf of Uganda in 2015, I think there was no wide consultation. That's why right now, no minister can go for some of these international meetings and sign documents there without consultation back home here, unless you are sent to go and sign. So that is one way we are going to track that, and it can still be raised, and we can point out the shortcomings of that particular treaty to Uganda. So we are sure that this very important sector of energy never pass, and even if they try that, it can still be a matter of national importance.
Thank you so much for ably dealing with the fear. One of the participants is congratulating you on retaining the chairmanship and expressing faith the unnishness of the committee will be dealt with since you're back, you bounced back. Evelyn Akech is congratulating you for retaining the chair. Yes, Jen, your hand is up. You have the floor.
Thank you, David. Joseph, congratulations, our honorable members of Parliament, Honorable Songa. Joseph, you didn't read out my comment that most of the bilateral investment treaties we have today were signed by ministers. They go for a conference, they sign the treaty, and that treaty is binding on the country. You know, and that's why I was expressing fear. And even when you look at the initial signing of the ECT, the way it was done, it was just the minister going for a meeting and they made all those commitments. So for me, I would like more assurance from our honorable members of Parliament, how they are going to handle. Thank you.
if I can just say one word, just this morning, we had the Business Committee of Parliament where members are the chairpersons of the various committees. And next week, the various committees are supposed to come with the work plan. And for us as the Climate Change Committee, we are going to look at all aspects relating to climate change in our work plan. And that's where we shall need the support of the stakeholders like you to come in so that we can address some of the challenges around this area. And one of them can be reviewing all energy and climate change related treaties in our work plan. And that can be one way of blocking any other person who wants to bring that treaty to Parliament, because it is already it will be already in our report. So if you can cooperate with us and we see how we can also review all the energy and climate change related treaties that may be detrimental to the economy, to the people, and to the planet, I think that will be very good.
Thank you so much. Honorable, another question has come to you from a colleague noting that the climate bill was passed by Parliament, and Robert, you could just unmute and raise your question. I'm trying to access it in the chat.
Yes,
properly.
Try to clarify that. Thank you so much. I am very delighted to see my friend Honorable Song for having been reappointed. Thank you. Congratulations. And of course, our very own Christine Kaya, I'm told, is also on that committee. But my question was, you remember the effort that we put in to have the climate change bill passed? You know, we went through the trenches with you, and I want to salute you in the 10th Parliament. You did an incredible job to have the bill passed. We did a lot of advocacy together with all the civil society actors and climate change activists. But we are very disappointed, you know, very many months down the road, the bill is gathering dust at the table of the president. Is it going to follow and like the fate of other bills that have gone to the president and have not been signed? I mean, dealing with an existential threat. Climate change is not only a crisis, but it's an emergency that we must treat as an emergency. Why is the president not responding to the cries of billions of Ugandans who are at climate change?
On that one,
thank you so much.
You know, the day we passed this bill, I think it was 13th of May, and it was almost at the close of Parliament. And so from the onset, they have to prepare the documents to send to be sent to the president, and that was done. The rules of procedure of Parliament requires that the president signs this bill within, or can also reject it within 30 days. We have not received anything like a rejection. That's why we have gone ahead to tell the minister responsible for environment to start working on the regulation. Definitely the president will sign it. This issue also came up in our meeting this morning of the business committee. Climate change was not listed not listed in this document we saw this morning as one of the bill that was rejected or pending. So that thing definitely, I want to assure you, it is going to be signed. That's why we are telling the ministers and of course you, the stakeholders, civil society, to come in so that we work on the regulation.
Thank you so much, Honorable, for reassuring the colleague that the bill will be passed.
It is already passed. That's signing.
Assented to, I meant, apologies. Yeah. Any other concern? I see Wilson Manishimwe, your microphone is unmuted. Do you want to say something? Wilson? Okay, colleagues, the plenary is open. We welcome comments on the presentation of the Honorable, on the presentation of Brenda and Lucia. What are your fears? They are here to respond to them, or do you have any alternatives?
But also, can I ask a question?
Yes, Honorable, you can ask.
Why have you brought this discussion at this time? Why discussing in a chapter? There's something happening around it. There's someone preparing to bring it here.
Yes, the hand is raised. Do you want to go first?
Okay, yes, I want to respond to the Honorable. Like we had shared from the beginning of the conversation, recently, Uganda expressed its interest to be party to the Energy Charter Treaty. And right now it is at the fourth stage that it is just awaiting to be invited to ascend to the ECT. So that is why we think this is a very critical and important time for us to have a conversation around the ECT.
Yeah, maybe just
I was about Lucia. Yes.
Just to add that right now the Energy Charter Treaty is currently going on a modernization process, so-called, which is kind of like a reform of the treaty. And I think it's important to also pay attention to this, because at the end of this year, we will have some news on how this has progressed. And up to now, we have seen some leaked documents that actually show that there's been little progress made on the modernization. So basically, some countries want the ECT to exclude the investment protection system, at least for EU countries, which is also something to pay attention to. And they also wanted to, talk about some of the articles, for example, what the definition of investor is, and to try to see how they could limit the treaty for, like more renewable type of investments. So all of this has actually not taken part of the modernization talks. It has actually been refused by some of the countries like Japan, Kazakhstan, to talk about this, because they don't want to change anything about the treaty. So I think that at the end of this year, some European countries have said that unless the treaty is more aligned towards climate goals, they will think about the possibility of exiting the treaty. So there are some relevant things that might happen during this year that, it's good to pay attention to. And as I said, right now the Secretariat is worried about the modernization process, but at the same time, as Brenda already mentioned, they are also putting effort and money to go to some of the countries that are further in the accession process, like Uganda, to support them on how to sign and access the Energy Charter Treaty. So unfortunately, there is not so much transparency around this, so we don't have many documents on this, only what we can see from the webpage or what we can ask our colleagues. But it's, we have to just pay attention, because when Uganda accepts the invitation, it will immediately go through a ratification process in the national parliament. And that might happen quick. So yeah, so we just have to be sure that we have some information, we have to be able to monitor this quicker, so we are, ahead of time. And I think the job that SEATINI and other organizations are doing in Uganda is very important to just raise awareness about what the treaty is before it goes towards ratification. Because if we only allow the Secretariat to talk about the treaty, it might be something appealing for some members of parliament. So we have to make sure that the other version of the story is also out there.
Thank you so much, Lucia. I see Jen has noted that ratification is done by cabinet, unless it's something to do with the war. I don't know if the Honorable has any response to what Lucia has just presented. There are other questions coming in to Lucia. Honorable, is your question answered? In the meantime, in the chat, David Mugisha is asking Lucia.
Yeah, I think he was muted. He wanted to answer and muted. So maybe we can go with his answer and then I'll answer David.
Okay, yes.
Hello.
Yes, Honorable.
Yeah, now I want to thank the people gave me the answer. Could you make for us a bullet point?
Hello?
The network is buffering.
Point on the short of Uganda and how Uganda can improve foreign direct investment without signing the ECT. And bring it to us. We shall summon Minister of Trade and Finance and we shall talk with them in the committee.
Okay, thank you so much. That would be one of the points to note and way forward. Yes. But I see, Lucia, do you want to respond to David? I see Jane's hand is up and Aaron's hand is up.
I mean, I think the answer is a bit what what Juan was just saying, no? Because there definitely needs to be much more benefit cost analysis done around any signing of any agreement and also on the Energy Charter Treaty. But unfortunately, this has not been done with any of the countries that signed the Energy Charter Treaty. So the benefits of being a member of the ECT, until now, we don't have like any evidence or proof of what the benefits have been, but we do know some of the risks about signing the ECT, which I already explained, which have to do with being exposed to $1 million lawsuits under international investment arbitration. But I think more dangerous is the fact that once you sign such an agreement, let's say that we all know that fossil fuel companies are already very engaged in politics in many countries. They, it's not unknown that big companies are already strong enough and have enough power to influence some policies. But if we have another instrument in place, which is the Energy Charter Treaty, they will also use that instrument to make sure that their investments, that their capital will be forever in place with the country. So for example, if a big company comes to Uganda and that company negotiates with the government conditions on how the company should be investing in the country, Uganda has the possibility to say, the conditions, how that company should behave in the country, what type of investments it should make, etc. But if that company comes in Uganda and Uganda has signed the Energy Charter Treaty, it doesn't matter because the government already allowed that company to be in Uganda with the rules that are written in the Energy Charter Treaty. And those rules are very pro-investor. So it's a very system that is biased towards the investor. And there's no other instrument that can balance that out towards the state. So it's dangerous in that sense, that and honestly, this is just my personal opinion, but as I said before, the EU is desperate to have energy resources. They will not care if Uganda has the Energy Charter Treaty or not, because they will still want to make contracts and negotiations with Uganda. So I mean, that's my, also my personal opinion on why the EU is so interested to have such an agreement, because like that, they will save a lot of time and they will make sure that they don't have any type of bad negotiations for them. So yeah, so that's one of the insights.
Thank you so much, Lucia. I hope David has gotten comfortable with the question he had asked about the cost-benefit analysis. It's also something that the Honorable was interested in. Aaron, you go first, and then we have Jen. I see your hands have been up for quite some time.
Hello, good afternoon. My name is Aaron. I'm a lawyer and climate activist. And I would like to thank Lucia, Brenda, and Honorable David for the
for the presentations. My concern is basically on, because you see, Uganda has already shown interest in joining the treaty. And once we are in that position, and you try to say they shouldn't, they'll raise issues of encouraging foreign direct investment. And once it gets to that line, that argument can be very hard to win. So my question maybe to SEATINI is, besides TNI and you guys, what other civil society organizations and stakeholders beyond this webinar and dialogue and MPs, what other mechanisms are in place to make sure that a voice is bigger and is taken more seriously? Because we all know that once more people come out, they have a better capacity to create change. So I don't know whether there are any other stakeholders besides Parliament and activists and you as SEATINI who are trying to create a voice on Uganda not signing this treaty or joining. Thank you.
Thank you so much, Aaron, for your contribution. We will have Nalunga and then the Honorable Christine Kaya.
Thank you so much, Joseph. The question from Aaron, I will leave it for Brenda. My question or my observation maybe is towards the members of Parliament, honorable members of Parliament here, that the challenge we have had when our governments are signing and negotiating these treaties is that the treaties are ratified in cabinet. So a minister goes and signs and cabinet ratifies without Parliament's knowledge. So I think we need also to look at the system of ratification so that all these treaties and agreements are brought to the floor of Parliament. Thank you.
Thank you so much, Madam Jane, for that concern. Yes, the Honorable Christine Kaya now has the floor.
Yes, thank you for the deliberations. My first request was to plan for how to popularize what is happening, because some of the cabinet ministers as well are members of Parliament. So it would be very important for us to popularize this charter, especially in terms of its effects and in terms of its consequences to Uganda, to the local communities. And so we would plan on how to popularize the content, and as well the respective minister and within the civil society fraternity. But I would also like to know how should we link up with the different ministries, because we have been reliably informed that it is the Minister of Energy that is at the top of the agenda. But I see as if this treaty also has linkages with the Minister of Water and Environment, as well as the Minister of Trade. And we would like to have these ministries share, because it looks as if the effects are too much on these other ministries other than the one for energy and mineral development. So I'm looking out for a way of convening the line ministries such that they are able to appreciate one another. Because if they just consult one ministry and yet, as far as investments are in Uganda, especially their contribution provided. So I would like the three, or the four actually, together with the finance minister, to liaise together, and how possible is it? How can we do it? Because I see if they share as ministers, line ministers, so we can cause, we as you, civil society, and some of us, the activists, we can cause an interface with these ministries and the line ministers to really deliberate and appreciate each other's concerns. Otherwise, thank you so much for planning for this. We have also gotten more information about the charter, and which we can share with the rest of the members, who can as well put the line minister to task as far as signing and the accession processes are concerned. Thank you.
Thank you so much, the Honorable Christine Kaya, for your views and submissions. I don't know if people want to respond to them, or we also read the question in the chat. Let me get to it. Davis was asking, is the process of the East African Community regional integration still alive, given the fact that partner states are going on with individual agreements that undermine the process? That's the question that David asked. Honorable Kaya, is your hand still up? Or we can get responses from the Honorable Vika Lawrence Songa on some of the pertinent issues that fell on his end, and then we'll invite Brenda. Brenda, you have a concern that was left to you.
Yeah, I would like also to beg that I will go for another meeting. But before I go, in line with what Honorable Christine has said, I think the Climate Change Committee is mandated by the rules of Parliament to check the responsiveness of the government of Uganda to all climate change related issues. And we work with all ministries, all ministries. And our work is not restricted only to the ministries, department, and agencies. It goes even to, that's why we interact with civil society, academia, and the private sector. So we are in position to call all the ministries responsible because of these energy-related issues, but also dialogue with the civil society is also very important, so that it can create awareness and give more understanding. But also in the committee, we can summon all of them. Thank you.
Thank you so much, Honorable Collins, for your contributions. It's interesting. Most of the way forward needs to be done. I see colleagues are supporting in the chat, calling for popularizing all that should be your outcome at this point. Speak to the involvement of stakeholders.
Yeah, I would like to leave, and I wish you good discussion and share with us the relevant information which you will have. But remember my bullets on the shortcomings of the ECT and how Uganda can foreign investment in the country without signing the ECT. Thank you very much.
Thank you so much, Honorable. We are glad that you spared your time to be with us in this discussion.
Thank you.
Yeah, hi. I think unfortunately I also have to leave because I have another meeting starting soon. But I'm really happy to stay in touch, and I shared my contact in the chat. And thank you, SEATINI, for co-organizing this with us. And yeah, I hope we manage to get things done, like, you know, with the campaign and everything that we can also help to support.
Thank you so much, Lucia, for being with us during this afternoon to discuss the Energy Charter Treaty and its impacts. Your deliberations have been great. Yes, Brenda, I think you should come in and respond to Aaron's question. And if we don't have further deliberations, I'll ask the Honorable Christine Kaya to honor us and have the final say.
Okay, Joseph, thank you. And Aaron, thank you for that question. If I got you right, you're asking who else is on board besides TNI and SEATINI, but as you can see, this is not just a call for two organizations, but rather one of the ways to bring together civil society organizations, policymakers, and other stakeholders within the East African region and Africa at large. And even actually from today's webinar, we've had on board representatives from all these sectors. So it is not just a SEATINI call, but rather a call that is out there, and not just to them, but it is also a very important call where we want the climate activists to also come on board and be part, because this is an issue that affects us all. So we are in touch with the several CSOs and multiple stakeholders. But if you would also wish to come on board, we would gladly work around and see how we can all amplify the voices.
Brenda, I can't hear you. I don't know if you finalized your contribution.
Yes, I don't know why you lost me, but what I said was we are not just as SEATINI, but we are. It is a call for every stakeholder that feels the responsibility and the need for such a voice to be risen, and for the responsible bodies to hear us. So everyone that is on board representing the different bodies that they come from, it is a joint call, and we look forward to work together and keep this collaboration so that our voice can be heard as a whole.
Okay, thank you so much. I'll invite the Honorable Christine Kaya to be able to have the final say and have this event closed. Thank you.
Okay, dear members on the platform, in a special way, SEATINI, thank you so much for organizing this. And members, thank you so much for having some time to discuss this important matter to us. Actually, if we decide to keep quiet about it, we would be behaving like the cabinet ministers who go quietly without consulting the parliament on some of these treaties that are signed on behalf of the country. So we are actually committing ourselves. I understand most of us on the platform are committing ourselves first to popularize the team, and then to also look at ways of balancing services and rights, especially in the era that Uganda really needs a lot of energy to help us with productive ventures. And so we are calling from different stakeholders and also call on them to further convene, and we come up with a unifying position that can really direct the line minister on the way forward. I know shall continue sharing information on the same, and this is the right time that as Parliament we are organizing ourselves. We have just been allocated committees this week, and the members are very vigilant at such information relating to guiding the government that they have planned to serve for the next 5 years. So please, we welcome you, and we are very grateful. Parliament as an that can do help us in deliberating on some of these much, and I declare the Zoom meeting closed.
Thank you so much, the Honorable Christine Kaya, for closing this event. Yes. Rogers, do you have any particular administrative announcements to make, or that's it?
That's it.
Okay, thank you so much.
You're welcome.